Well, good afternoon, good evening, wherever you are. This is J-Boy 1878, and today we're going to look at the recent court hearing regarding restitution from Mr. Darrel Brooks, the man convicted of killing 6 people in the Waukesha Christmas attack. So let's have a look. We're going to start off from the defence attorney, who's now representing him, um, make their argument, and then we'll watch and listen to Judge Doro make her finalisation.
Thank you, Judge. Although I'm relatively new to the case, I can state just from my review of the file so far, I haven't heard anything at all about anybody offering any kind of book deal or any kind of sums of money in any way, shape, or form to Mr. Brooks. I think it's the odds of Hollywood knocking down his door to give him lots of money for his life story. I think, given the totality of the circumstances of this case, I just think are so minuscule that I don't think that argument should be given much weight. I also couldn't imagine any of the media, whether it's a YouTube blogger or the people that are next door to this courtroom, offering Mr. Brooks any money for some kind of exclusive interview. I cannot foresee the future with 1,000% certainty, but I think the odds of that, again, are just exceptionally low. I appreciate the fact, Judge, that the state's stipulating that he's indigent. I think counsel mentioned minimum, and I just want to make sure that the court recognizes that we're not talking minimum wage as a legal $17, $18, $19 an hour for prison work. If he's offered work in any of the facilities that he's going to be serving time in, at best he'll be getting perhaps a few dimes an hour for janitorial work or cleaning up the kitchen. The type of wages that are earned by inmates in our correctional system, they're not used to save up lots of money. They're used to sometimes save up to buy a bag of Doritos or some deodorant or toiletries. That's essentially his earning capacity. If they let him work perhaps $1 or $2 a day if he works the entire day. So that's the reality of what he's facing. And Judge, counsel touched on this, and I appreciate her argument. Frankly, whether you order 50,000 or 500,000 or 5 million, it's very unlikely that Mr. Brooks will be able to pay even the smallest fraction of that. But this hearing still matters. This is not just a moot point or a moot exercise, because you do have the duty, Judge, to balance 5 sometimes competing factors as listed in Wisconsin Statute 973.2013. I mentioned it in my motion, and then, of course, the 5th factor was I sent a letter to the court about that yesterday. The 5 factors are the amount of loss suffered by any victim as a result of the crime considered at sentencing. 2, financial resources of the defendant. 3, the present and future earning ability of the defendant. 4, the needs and earning ability of the defendant's dependents. And 5, any other factor which the court deems appropriate. Judge, I'll go just a little bit out of order. On subsection 4 regarding Mr. Brooks' dependents, recognizing that he's currently serving multiple life sentences consecutive, realistically, he's not going to be able to support his dependents anyways. And so that factor isn't really on point for this hearing. On the first criteria, the amount of loss suffered from the victims, I'm not surprised that the totality could be in the millions of dollars. I'm sure it's an absolutely enormous amount. And you have that discretion to give that factor great weight. I concede that. But I also hope that you consider the next 2 factors as well, and they kind of go together. His earning ability and his current financial resources. I hope that gets great weight as well. She's had significant financial problems even before this case. I believe he qualified for a public defender from day one. If he were to testify, he would testify that he had no savings, no assets. He doesn't have any kind of inheritance coming down his way. Nobody owes him any kind of money. I don't think anybody would dispute those facts. If you add on another $500,000 or $350,000 to what he's already been ordered to pay, which is in excess of $171,000, then you are sending a message that the two factors, his poverty, his earnings ability, just don't matter. And I hope that they should be considered. Finally, Judge, subsection number 5 is the catch-all section, where you can consider any other factors which the court deems appropriate. I'm not sure if the amount of restitution in document 566 is the sum total of what might be requested in future restitution hearings. There is case law that states that a request could be made well past the 90 days after the sentencing hearing. We could object to it, but a lot of courts have upheld those. And I believe, just for the sake of judicial efficiency, since he cannot pay anyways, since he really couldn't raise more than a couple of dollars a month anyways, is it worth the court system's resources, our time, the court's time, the community's time, to have potential extra restitution hearings when the ability for him to pay anything is going to be minimal or nil? And Judge, I guess one last thing. I would respectfully disagree that this is about rehabilitation. Given the length of Mr. Brooks' sentence, I think this is just more additional punishment, adding extra zeros to the judgment of conviction for money that he owes. I recognize the gravity of the harm, and I mean no disrespect to anybody who suffered any injuries or the medical bills from this case. But given the totality of the circumstances, his multiple life sentences, I just don't think it makes sense to add on any additional restitution. It's just more paperwork, potentially extra hearings for no really just purpose except to add extra numbers on the judgment of conviction. I'm happy to answer any questions you might have, Judge, and thank you.
Thank you.
Well, I thought that was a well-reasoned group of answers from the attorney. Is he ever likely to ever pay anywhere near this? But I also think there's always the possibility, you can't rule it out in this world, that some Hollywood producer, some interviewer, some magazine, books will try and get his side of events and want to pay him a few dollars. And I think if that ever happens, then he shouldn't financially benefit. It should be to repay the state for the cost of reimbursing those victims who were severely hurt by him. And I think that's where we stand. That's why the escrow accounts are there, isn't it? Now we're going to listen to Judge Darrel give her verdict.
First of all, I do want to thank the parties again for the stipulation. I think that certainly has made this hearing one that is running quite smoothly, but also kept victims from having to testify again regarding the loss that they suffered, and even, frankly, the representatives from crime victim compensation or the insurance companies related to this. I also appreciate the stipulation from the state regarding the indigency. I think that's a testament to both counsel here and their willingness to look at this objectively and what the purpose of this hearing and what the court needs to do. It is true that the court does need to consider the statutory criteria in 973.20. That's been referenced by Attorney Covey, both orally here in court today and in his motion to deny restitution. There are 5 criteria, really, when you look at the statute: the amount of loss suffered by any victim as a result of a crime considered at sentencing, the financial resources of the defendant, the present and future earning ability of the defendant, the needs and earning ability of the defendant's dependents, and any other factors the court deems appropriate, really what we would call the catch-all. Obviously, this concerns a case where Mr. Brooks was convicted of dozens and dozens of crimes based upon conduct stemming from him driving an SUV through the Waukesha Christmas parade. There were 73 named victims, one of whom was the victim of the domestic abuse-related convictions, and then, of course, the 6 individuals who perished as a result of his conduct and the 68 others who were injured. There are family members that are represented by each of those victims as well. This was and remains a very significant crime that has and will have lifelong effects for not just Mr. Brooks, not just these victims, but the community as a whole. And the losses that were suffered apart from the death and the injuries is only in part represented by the dollar figures that have been requested by the state on behalf of the victims. And that's what prompted one of the questions to Attorney Opper is that there was, and I think perhaps, I don't know if it still has any money left in it, but we know that there was a fund set up by community members, really funded, I'm sure, if you were to look carefully, probably internationally, with millions of dollars that helped defray costs and the loss to many of the victims. There was testimony, whether during the trial or probably more at the sentencing, of individuals who did not have insurance and suffered out-of-pocket losses, and thankfully the community stepped up, crime victim compensation stepped up, but it would have been significantly more in terms of the dollar amounts that the state is seeking, but for that fund that had been created and used to help the victims of Mr. Brooks's crimes. And so I think that's an important consideration for this court to consider. In addition to the type of loss that was suffered here, I mentioned this earlier, there was death, great bodily harm, certainly emotional and physical trauma, and because this involved a parade and Mr. Brooks driving through it, there's also that sense of security and safety in our community that he robbed not just the parade goers on that fateful day, but really the community, the state. I think anyone who's heard anything about this case would feel a real sense of security that was stolen by Mr. Brooks. I do think the state's argument on rehabilitation is a solid argument. The bottom line is Mr. Brooks completely minimized his conduct both during the trial and at sentencing. And it is important, if only symbolic, that while he is in prison for the rest of his life, that whatever meager sums he might make with a prison wage, that there be a reminder to him why there is this deduction from his monies, that his ability to go to the canteen or to buy some extra item that's not otherwise provided by the prison, that there be that reminder to him that he doesn't have even the full access to whatever money is on his account. Now, I'd remind everyone that the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies. And I think that's an appropriate cap. I also think it's important that this court consider that the vast majority, I shouldn't say vast majority, but a significant amount of the restitution is to crime victim compensation, which is a state fund, largely, if not all, funded by taxpayers. And even if there were some grants that are there from federal resources, which I imagine there might be, that's still taxpayer funded. And so I think that's another consideration for this court to look at and consider. Now, I do have to balance. I'll look at all the criteria. Obviously, significant amount of loss. That's criteria reflected in sub 13 sub A. Sub 13 sub B, the financial resources of the defendant. Clearly, they are extremely limited at this time. However, there is absolutely no doubt in my mind that the possibility exists for Mr. Brooks at some point in the future to possibly profit from a book deal, a made-for-TV movie, a movie, whatever it may be. Maybe it's just doing an interview or whatever the case may be. I don't think that can be ruled out, even if he is obviously the person who was convicted of that. But there was international attention. This court had Court TV in to stream the trial. This court has always streamed every hearing as it relates to this case, in part because of the number of victims, and I could not, I don't have a courtroom big enough in this county to hold all parties involved. Certainly during the trial, this courtroom was packed on a daily basis. And to say that the trial went viral, I think, would be an understatement. And so all of that relates to, though, that catch-all factor and the possibility that Mr. Brooks could come into a sum of money at a later point in time because of the story that he could provide or tell on his own behalf. You need only look at Netflix to know that crime stories are incredibly, they're things people want to watch. People find them interesting. People want to know the why. They want to know the how. It's certainly not just this case, but we've seen it, and not that that's been on Netflix or anything, but other cases have captured the attention. So I don't think it's beyond the, it's not an impossibility, let's say. It's, I think, a very real possibility that someone might produce something someday for more of a commercial or theatrical type purpose, even if it's a true crime type situation. And that it's possible that Mr. Brooks could profit from that. And that certainly is why at the time of sentencing, the court addressed the request by the state related to the escrow account. I think that's important to do that here. And so when I balance all of these things, when I consider the significant amount of the loss, the court's desire to hold Mr. Brooks accountable, and even if it's a small reminder with his prison monies, that does serve a very important rehabilitative role, because even though he's serving successive life sentences, we all hope that one day he truly is able to accept full responsibility for what he has done, not minimize his conduct, and so that this award of restitution in full, as the state has requested, is important. And I will grant the additional amounts, as I indicated earlier. It's $10,246.20 to crime victim compensation. That total then to them for the judgment of conviction is $134,466.85. Then to Wilbur and Associates, which is Hartford Insurance, $108,000, $164.61. Optum Subrogation, $118,805.62. And then Progressive Insurance for victim GGG, $10,000, and Progressive Insurance for victim Q, $104,662.64. That is, of course, on top of what its court had already ordered to EMC Insurance of $47,193.29. So again, I'll grant the request of the state. Will also include that it be payable out of any prison monies per state statute, and the court under 949.165 makes the additional amounts of restitution ordered today subject to the escrow account under that statute.
So there you go. Everything's been granted by the state. Any future earnings, any amount, prison income, 25 cents in the dollar, and then any outside earnings, books, films, rights, will be paid into this escrow account to the reimbursement of all these costs. But it's fascinating hearing there, because you can actually see the difference between having legal opinion and trying to do that on your own. How many of us would understand half the words coming out what's going on? And that's why I think Mr. Brooks has finally saw sense and allowed some representation for himself. Now, thank you very much for watching, listening, wherever you are. And there now follows a very important message. All I'd like to ask is, if you've liked what you've watched, listened to today, like and share, especially the likes. Just starting up. Give me some support. Like and share the channel. Thank you.